allowed to share screen. Okay, everyone's allowed to share screen. Okay, well, live then. It's over to you then, Anthony. And welcome, Paul, and welcome everybody else on the stage and everyone in Facebook land.
Okay, yeah. So this is our 39th webinar on the trot regarding styling it shut down Wilson and Rowe, the illegal bailiff, scandalous, but it applies to every other bailiff and illicit activities going on in the court system with so many victims, probably 10 million plus victims. So I hope we can pull it off. So we came up with the idea that after you've exploited your bailiff, your police, your solicitor, your counsel, you can't keep knocking around sideways when they, none of them can verify that there was a lawful process against you. So the natural thing to do is to escalate it to the Lord Chancellor, based on the jurisdiction and case precedent. I'm aware of a case called LL versus the Lord Chancellor, and there are other cases. So what it is, we've got Paul Millinder here today, and he's got a case, and it's not with a bailiff or anything, but the interesting thing is he came up with the same wisdom that the Lord Chancellor is the man, and he's got a live case in the High Court against various claimants, one of which is the Lord Chancellor. So he's done us an amazing favor today to postpone his dinner date with his wife and to come and give us a briefing on the rationale why the Lord Chancellor is the man and a brief outline of his case. So Paul, take it away.
Yeah, very simply, I brought an action against the Lord Chancellor and HMCTS for failure to administer insolvency set-off, the scheme of law insolvency set-off, in respect of both of my companies. And I identified a widespread fraud whereby the system, the establishment, judicial and insolvency, the executive side of the government and the judiciary have been bypassing the mandatory law of due process on a widespread scale in both corporate and personal insolvencies. And what they're doing is they're bypassing this mandatory rule and they're operating off various degrees of nullity. So we need to re-educate them. We brought two actions, one in the King's Bench Division High Court for a declaratory judgment, because they also jumped all over my privilege of absolute immunity from suit. I brought a criminal prosecution against these people, these corrupt judges, allegedly corrupt judges. And they relied on the doctrine of immunity from suit, which bars any civil action against a judge acting within the remit of his jurisdiction. And exactly the same doctrine of immunity applies to litigators as it does private criminal prosecutors. And I brought a private criminal prosecution against various judges for failing to administer this rule, as I did civil proceedings under various companies. And throughout both sets of proceedings, both criminal and civil, they evaded the preliminary issue, which was all about failure to administer the mandatory rule, to defraud me personally of over £10 million in respect of both of my companies that had cross claims that substantially extinguished the claims by the club. So that's the background as to why I'm going for them and why I'm going for the Lord Chancellor. Quite simply, the Lord Chancellor is responsible for judicial independence, and indeed everyone everyone responsible for the justice system has a statutory duty under Section 3 of the Constitutional Reform Act 2005 to maintain judicial independence, and that's certainly not been happening. So we are taking them on head on We're also bringing proceedings here in Hong Kong, in our High Court of First Instance here, because these guys trampled all over my privilege of absolute immunity. And I said to them, as I did in court the other day, what's good for the goose must also be good for the gander. You can't rely on judicial immunity and then say that I can't rely on absolute immunity in respect of the evidence I'd first given before Deputy Chief Magistrate Ikram in the Westminster Magistrates Court in respect of the same crucial evidence and facts. The privilege of absolute immunity goes back to the 1600s. It's widely recognized in international law that the words spoken by a judge or a litigator in court are protected by an absolute privilege. And that also goes for the evidence that we lay as prosecutors, in which was what I was doing. And what these people did is that they jumped all over my privilege of absolute immunity and decided that they were going to bring civil action, vexatious civil action against me, using a series of restraint orders to try and prevent me from getting justice, shutting me down at every available avenue, with a series of these civil restraint orders. The problem that they've got is absolute immunity applies to all civil actions. So everything that they've done is void from the outset. They have a real problem dealing with that at the moment. Bit of background, that's where I'm at. So the King's Bench, excuse me, so the King's Bench proceedings deals with my absolute immunity and the fact that they've jumped all over it whilst they seek to rely on it to prevent themselves from being sued for civil actions. Crown immunity works in exactly the same way. Judicial immunity, witness immunity, all falls into the broad spectrum of the doctrine of immunity from suit. And this particular doctrine, as I say, is so well established and it's been going around since the 1600s. The judges rely on it to prevent themselves from being sued civilly. And as I said, what's good for the goose must also be good for the gander. So this is all about two-tier justice. If I can't rely on the statutory law, if I can't rely on the statutory scheme of law insolvency set-off to gain restitution, for contractually tortious wrongs within the remit of insolvency proceedings, then neither can anyone else. If I can't rely on these judges to act independently in the proper administration of justice, and that means impartially and hearing both sides' story, then neither can anyone else. And this is where we need to come in and take direct action, like we're doing, to get the accountability, to hold them to account directly for their actions.
Yeah, well done. Thank you very much. So we're seeing more and more people take on Wilson and Rowe and the Lord Chancellor. I think we all know the case of Wayne Layton. I think he's taken on the Lord Chancellor as well. They're trying to give him some BS with his trying to superimpose someone else, but the Lord Chancellor is the man. Yeah, so what we're doing, Paul, like I said before, we feel we start lower and escalate, and at the end of the day, if everything else fails, the Lord Chancellor, plus it also shows a conspiracy, because if you've got several parties all bullshitting you at once, blatantly against the evidence, there must be a conspiracy. It can't be coincidence. And if it's happening to a lot of people, it's even more ammunition. I mean, the justice system in this country now, from a point of view of council tax, bankruptcies, just general CCJs. I mean, you know, we had a letter from the Traffic Enforcement Centre a couple of weeks ago saying in black and white, we did not issue the documents, but we got bailiffs clumping your car saying they have a warrant from the Traffic Enforcement Centre. So it means, you know, it's a wholesale capture of the court authority. And I'm really proud of you that you've escalated to the Lord Chancellor, and I think we have other cases we have to watch. And I believe there's an idea that we can pull support. Now, this is a layman's idea, so I'm going to try and share my screen. I just drafted a little, not a template, it's kind of a template, but I'm going to use it myself where I see other cases. I want to submit my evidence or my concern to the court. This one is kind of for the Andrew Wilson and Co. But if I send a letter into your case, Paul, yeah, to the court manager and say, look, I'm aware of these matters. I'm aware of the corruption. I'm aware of people acting without due process. I have a whole stack of bankruptcy cases, some of which we've won, where there's no proper due process. The appointment of the trustees is, not valid at all. So I believe there is a place to, I suppose, as a witness and fellow victim, that we can send in documents into the court in cases where it involves somebody who's, acted wrongly against us, on the basis that this party is totally without jurisdiction, and the court is obligated to invoke the anti-fraud policy. I went into Central London County Court and the High Court last week to support Paul McGowan. And we asked several people in the court at different departments for a copy of the anti-fraud policy. None of them knew what it is, or where it's supposed to be there available and to pick it up and hand it to the customers. So it's just an element of it where they seem to be acting like it is not possible for anyone in the court system, the judiciary or the administration, to actually be wrongdoers. And if you could just clarify, Paul, because you are big on this, I would appreciate, because I talk about it a lot and it helps me a lot, and people are not aware. The distinction and the judicial separation between the administration and the judiciary. Can you just put your barrister's 2 cents on that for us?
By law, there has to be a constitutional separation between the executive and the judiciary. And this goes back to before the 1300s even in English law. And that's now cemented by the Constitutional Reform Act 2005 that places a statutory duty on all responsible for the justice system, all ministers, to ensure the continued independence of the judiciary. That goes for the Lord Chancellor, who's predominantly responsible for the duty, as he is the conduct of the judiciary. The second duty, well, that duty is actually shared by the Lord Chancellor and the Lady Chief Justice in the current office. And they're both jointly liable for judicial independence and the conduct of the judiciary.
Yeah,
there's no regulation. There's no regulation of the constitutional oath of judicial office in the UK. This is the massive problem, because in fact, the Judicial Conduct Investigations Office has no investigatory capability. They can't investigate judicial. It's a scam, I would say, yes. It's a total scam, and the people that are employed in there are wholly inefficient. They are there to draw people out, I believe, waste people's time, lead them into belief that actually they are looking at something, but they don't actually have the wherewithal to look for it in the first place. A similar kind of non-regulation that we see across the legal sector, unfortunately, in the UK. The Solicitors Regulation Authority, the Bar Standards Board, the Financial Conduct Authority. These are all the non-regulators that have been put in place by this establishment to ensure that people that do get defrauded and have got genuine complaints are passed along the way and nobody gets justice, unfortunately. That, in my experience, in my opinion, that's what's happening.
Well, we got 11 million mortgage holders being robbed blind. And I'm not aware of the FCA having ever taken action against one of them. And they're raking in, 20%, that's my understanding, being a regulated person for 30 odd years and paying huge fees. My understanding is 20% of your investment, the cost in it, is going towards the regulatory cost and burden to protect you. And we can't see any evidence they're protecting the vast majority of people from very, very clear fraudulent practices by regulated lenders and other people. So what we're getting, Paul, is quite a few cases now where we're in court on Friday with Paul McGowan. Just somebody had an order for the third time, and the court staff is telling us no one made an application to get an order, but they refused to put it in writing. So how crazy is that? So they sent us to the High Court section, and the High Court section, before they came to us, said they went and discussed the matter with Judge Eastman. So what really happened there is they don't have an order from Judge Eastman or a direction or anything, but what is happening there, in my opinion, they're using the title of the judge as a deflection. The judge has no jurisdiction. This is where you're talking about the separation of powers. He has no jurisdiction, administrative matter. You said no one's made an application. We need something in black and white so we can, we can prove it. So this is an example, and we're finding it more and more common that people are being told the matter is being referred to a judge, blah, 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 when the judge has no jurisdiction, but it's being used to deflect. The real issue is there is some kind of fraud going on, and they want to just kind of give some credibility to their part of it by just saying there is a judge involvement of some sort. So can you just tell us what your opinion on that is?
The whole system, Anthony, is completely dysfunctional, in my opinion. We're seeing in the banking case that we're involved in, we have another banking case in court at the moment where it involves Barclays Bank allegedly falsifying loan documents, which I've seen, falsely claiming that there are a loan taken out by this company, 3 different loans in the sum of circa 102,000, when no such loan was ever taken out. And I've seen this physical hard evidence of these false accounting statements from Barclays. And it would appear to me that these judges, so-called judges, and finally you mentioned Master Eastman, he was one of the ones involved in that case, along with Master Brown and
what
a few of these other masters. And yes, yeah, and well, it's a small network that are doing this. And I'm afraid to say that in my learned experience, these people are effectively taxpayer-funded criminal racketeering agents. and they're acting as agents for these corrupt corporations to cover up and essentially underwrite fraud. They're falsifying documents, they're falsifying court documents, they're allowing counsel to do whatever. There's no regulation.
Or there's
no regulation, and there's no proper administration of justice.
But Paul, I come back to this thing. The court's anti-fraud policy. It's there, it's in black and white, it's powerful legally, but nobody is pressing that red button where the evidence is there, so clear. I mean, we got company that's listed as dormant. They got no insurance. They've got a listing at the Law Society, Andrew Wilson and Co. with a number. No human beings on that listing. And Andrew Wilson and Co. is a dormant company. So how do you feel the Law Society, like we're doing these webinars where this is number 39, how do you feel the Law Society can justify having a dormant company with no officer listed? What's your opinion on that?
The Law Society, its primary interests are the interests of its members. It's run by its members for its members. And essentially, the Law Society will pass the regulation of companies or members' companies to Companies House. One passes to the other to pass the buck, and everyone gets led round the houses.
Now, you know, you have an insolvency case, and the insolvency service has a department specifically that deals with
You're going to say enforcement.
Fraud. Company fraud.
Yeah, enforcement. Yeah, call it enforcement, company fraud, delinquent directorships, delinquent liquidators, and delinquent insolvency trustees. But they don't do a very good job of enforcing. The case that we've got in court at the moment, there are incontrovertible offences committed by liquidator, summary-only offences, that should have been reported by the previous office holder to the Secretary of State for enforcement. And they amalgamated what was the BEIS Insolvency Enforcement Team, so that's actually now taken care of under the Insolvency Service. So in-house, they have their own core prosecution capabilities that are meant to deal with these Insolvency Act offences in this case. And these are offences that in this particular case were committed when the liquidator fails in his duty to do certain things during the course of his appointment. For example, an offence is complete if at the end of each year the liquidator fails to file a return for members' meetings or company creditors' meetings at the end of each year. So if he fails to do that, it completes the actus reus mens rea of a summary offence. In this particular case, multiple offences had been committed that are so easily proven in the public records, in the public domain, looking at comparative companies that have been wound up from this window to this window. You can see company X that was put into liquidation. There's the annual reports, the annual returns filed at the end of each year. And yet, in this company, there's none proving the offence has been committed. It's that simple. And they've bypassed all that. They've been lying and saying that there's no offending when they knew that there was. So there's a big problem with widespread perversion and absolute contempt for the statutory criminal law. And that's been happening in a number of different cases. So there's just an evasion of the law. The public interest requires that where an offence has been committed, generally the public interest requires that the offender be brought to justice. Otherwise, there's no point in having these offences.
Well, what we're finding is in all the departments, you know, from the children's, insolvency, every department, they have these checks and balances that don't work. I can't think it's a coincidence, you know. I mean, in my own case, I don't talk about this too much, but we had the child protection officers being jailed for extreme child offences. So it's working in reverse against the public, and it's almost all the government departments. We see what is happening with the Jeffrey Epstein situation. Donald Trump alone had 1 million. What more do you need to at least question him on the caution? Nothing. So I see like it's time, it's a turning point. The public has to step up again. It's the public who are the real bosses. These people have captured the authority and are abusing it. And thank God we have social media, because the mainstream media won't even publicize these kind of things. You know, we got Ian there on this chat there, Ian D. D'Souza. I mean, in his case, they're bankrupting him for liability orders. We have a written from the Lavender Hill Magistrates Court that they didn't issue any order. They don't have no records. We have it written from the Merton Borough Council. There was no eviction notice served on them. We have the trustees gave up and said we don't want any more. We had armed police officers attend the man's house to evict him. And when we check with the police internal system, they have no log of any officers. And these are people with guns. And still, they're still pursuing the case, and no one is taking action on all this. I mean, how much more evidence can you get, and how serious, you know, that the court is confirming we didn't issue nothing. And here the solicitors are still pursuing. Where is the law society to jail these people? So just wind us back a little bit, Paul, on you filed a criminal prosecution at Westminster Magistrate.
Did, yes. Yeah.
And did they give you the summons in the end?
Well, no, the Chief Magistrate, the layer that was installed, the Deputy Chief Magistrate Tanweer Ikram, relied on the
what's
doctrine.
The name? Let me just write that down.
Tanweer Ikram, the Deputy Chief Magistrate, relied on the doctrine, and I was prosecuting an insolvency registrar of the High Court,
right?
A judge, well, a Master High Court registrar of the Insolvency Court, for failing in his duty to administer the law, and for lying to me about the automatically engaged rule duty of inquiry in 1411 of the Insolvency Rules 2016. He lied to me in court, and he lied to me in his judgment, and said that the rule wasn't engaged when it was. And later judgment came in that affirmed that I was correct. Long and short of it, it was a very strong case against this insolvency registrar. And Tanweer Ikram said that I couldn't prosecute him, and he wouldn't further consider the merits of the prosecution, because Tanweer, he said that the defendant, the subject, was subject to absolute judicial immunity, and that therefore he couldn't be criminally prosecuted. In other words, he made this offender above the law. However, there's a judgment by the former Master of the Rolls, Denning, M.R., called Cirrus v. Moore, 1974, and it's all about the doctrine of judicial immunity from suit. And the long and short of that is that if a judge acts in the least degree corrupt, or takes bribes, or perverts the course of public justice, and I summarise by saying if they commit a criminal offence in office, then a judge can be brought to justice in the criminal courts, because the immunity from the immunity from suit only applies to acts within his jurisdiction, and obviously only civil actions and not criminal actions. Nobody's above the law. No judge is above the criminal law. And that's what the Master of the Rolls was saying in his final judgment in Cirrus v. Moore, 1 QB 118 1974, that in fact precisely that nobody's above the law, and that absolute immunity only applies to civil actions, and what's good for the goose also has to be good for the gander. So they can defeat my absolute immunity as a criminal prosecutor laying information against a registrar by attacking me civilly with these civil orders to prevent the truth from coming out. And then they can rely on the doctrine of judicial immunity, completely in the wrong context, to evade criminal prosecution. They've defeated the rule of law, these people.
Well, that's interesting, because I did file a criminal thing in my claim against the parties in my case. I didn't put the judge in it, but the three parties, which was the court manager, the chief executive of the bank, and the solicitor, they all disappeared. The chief left the country, Martha Bockenfield. The solicitor, the whole firm shut down, Latian Doe Solicitors, and the court manager, he just disappeared, can't be found anywhere. And the judge actually resigned, although he wasn't in the claim. And they still never gave me the summons, but I feel just filing it, and I did manage to get it stamped, which was a exercise, but just filing it and serving it, it was a bit like the cat amongst the pigeons. And I think one of these days, Paul, what I'm going to do with this work we're doing is just to arm people with the process. And what I did is brutally simple. What I didn't even use their forms, but the fact it was stamped and approved by the court means it must have been correct in its format. So I believe that's something we have to dust off and revisit. But well done for doing that, and for explaining that judicial immunity doesn't apply in the criminal fraternity. I'm going to tell somebody off to.
I think somebody in the room has got some loud music on. He's just told to turn it down, I think. Yeah, I mean, going back to your point where it's two against one going into them courts. You know what I mean? That's the way it certainly feels. Rather than 1 against 1 with the referee stood in the middle, it's most certainly 2 against 1. Yeah, you're back in, Anthony.
Hi. Yeah, so I suppose, Paul, we can talk another time, but I'm very aware. I really appreciate you postponing your dinner date to come and do this, because you told me after we already sent the emails out. So you're free to go.
Lovely.
I'd appreciate another time you come and go deeper into your case.
Sure.
It's of interest to the activist community, and well done for standing up. And we'll see if there's any way we can support or promote. I suppose this is a little promoting of your cause and your arguments in the public domain. So thank you very much.
Cool. Thanks a lot. All the best. Great work, guys.
God bless.
Thank
you.
Thank you. Bye.
Yeah, Andy, what do you make of all that?
It's I mean, it's there. I mean, the clear side of the immunity, which again, it's very clear. Like it's not. It can't be criminal. They can't be if they're doing a criminal act. It's a criminal act. There's no immunity over crime. Full stop. They're immune from being sued on a monetary scale on a civil claim against them. That's basically what they're saying. They're claiming, you know. But ultimately, like, you know, at the end of the day, if it's if you have to go, I mean, that's the other side to it. I mean, because obviously the police are never going to get involved. The police are never going to accept as a crime report. So, I mean, how do you actually get it done as a crime? And that was the other side to it about going criminal, going to the civil, taking it into the civil.
You don't need the police. I mean, if you're doing a private prosecution, you don't need nothing from the police. As a matter of fact, if you do it the way we are doing it, or we're recommending, the chief constable will be one of the offenders, because you knock his door and you nail him for failing in his duty and for being part of a conspiracy, so he'll be part of it. And all these things need numbers, because if they have money, they have power. What the public has is the numbers, but we have to invoke it. That's why I'm trying to go public with my work and reach as many people as I can, because that's the only magic the public has. The public doesn't have the money and the corridors of power that the criminals have captured. So in the past, we never had media. You know, the old media would never publicize. Even now, they won't publicize it. Look how crazy this topic is, and look how much time and effort we put in, and the media is not picking it up. So, you know, we have a little opportunity here. They do give us a hard time with the algorithm and ban us from time to time and restore. Imagine being banned and you haven't done anything wrong. I mean, what's world we're living in? So I might have called a few people child traffickers, which is correct and fully defensible. But don't ban me. Just ask me to justify my statement, you know, which I'm perfectly capable of doing. And I don't say things I can't back up, you know.
Exactly. It's public knowledge if they choose to search up and look. You know what I mean? One of them was even done for making pornography, child pornography. Never mind just the child pornography pictures. And that was the two police in your case. Well, just as a point, like there was Shap had a hand up. I don't know if you want to. Did you want to say something?
Hiya, yes, it's such a coincidence because I was just watching the video from Lord Denning this morning, which is what Paul pointed out. I put it in the link for everyone.
Yeah, okay, about the judicial separation.
Yes, it says, when a court makes an error on a point of law, it's outside its jurisdiction because the court has no jurisdiction to operate outside the law, Lord Denning. And I put the video link in, YouTube video link.
Right. I think we have this this thing drummed in our head that we give them a what they call authority bias. They have more respect than they're entitled to. And I think you should respect everybody, you know, whoever you are. You deserve respect just for being. But if you're doing some horrible things by abusing a respect that you didn't earn, you got a respect because you got a title and a position. You didn't earn, you know, and then you start abusing that position for gain or, you know, a nefarious outcomes. But they're still retaining the respect from us. And many times I'm seeing the judge's authority being used. I mean, in Kelly Jeffrey's case, the judge wrote her a big letter, like a big bundle, and sent it to her and signed it, the judge. And she sent it back and stuck the mail fraud sticker on it. I've shown these a few times. One of these babies here. Yeah, put it on the envelope and returned it to the court. Just return it in the post, and the outcome of that was he stopped. You know, he stopped, and as a matter of fact, following a complaint to the Judicial Investigations Office, The judge said he's not allowed to act on the case unless she gives him permission. And she said, yeah, if you're going to drop the case, you can have permission. So he dropped the case. But, you know, it followed a process. But this is where they're overstepping their mark a lot, and people are getting, every day of my life, I'm seeing people are getting misdirected, get into pursuing the judge. The judge has no jurisdiction unless there is a properly constituted claim on the table. And how many of us can show that there is a proper claim issued by the court? They show us the file, give us the computer record. We're not seeing many, you know, one or two. In my own case, I got my computer record and it shows a clean slate, nothing against me. So that means their order, they didn't make an order, they made up a certificate. A certificate is not an order. So I carry myself in the world that I never had any conviction. And it helped me a lot, although I never had a full remedy. But
Yes.
I had the moral victory, and it helped me in my life. If I had to fill any forms and whatever, it says, have you got a conviction? I perfectly 100% say no. So, yeah, this is interesting, and it's very fascinating what Paul Millinder is doing, and his case doesn't dovetail neatly with what we're doing, but it's the same principle. And I'm just doing something. You do the 5 eyes document, you ask everybody for the proof of whatever they're supposed to have, and they can't produce it. That becomes your proof of conspiracy, and you take on the Lord Chancellor, just like Paul did. And once we get numbers and a bit of publicity, and we have opposition like Wilson and Rowe, where they have absolutely no foundation on any level, how can we lose? That's my question.
Hello,
Hi. Yes, Al.
how's it going?
Great.
My mum phoned me this morning and said you're doing a Zoom call about dodgy warrants and
Why are so many moms following me? That's what I want to know.
probably because their sons like me are getting in a bit of bother.
Could be.
But my case started from the electric company alleging that I hadn't paid my bills or something, and then they sent around a bailiff company called Seeka, who attended my property, and
I've got Seeka.
I told them
spell it? How are you spelling that?
Seeka.
Okay.
They're part of a group called M Group,
Okay.
and they came around with a so-called warrant from the magistrates, Peterborough magistrates, and it didn't appear signed to me. It was just it just had some names printed on it. It didn't say who the judge was, no signature. So I told them to go away.
Right.
And they left. They called the police. The police didn't come. 2 weeks later, or 3 weeks, another group of the same company came. This time the police attended, and within minutes took a hostile attitude, started telling me to let them in, and then I was filming it on my phone. After about 45 minutes, it escalated to the point where the police officer, I have a gate in front of the front door. So he's reached through the gate and he's grabbed me and he started throwing me around. And I've asked him if I'm under arrest. And he said to me, at the moment, you will be in a minute. So I broke free from him. Yeah, I broke free from him. I went back into my house and then I've called the police. And they were saying, oh, the police are there, you should open the door. They've then gone around. They've got a locksmith there, and the locksmith's trying to open the gate. The policeman's trying to force the gate open with him. And they've gone through my neighbour's house into my garden, and then they've started trying to get through the back doors. And he's picked up a brick. The policeman picked up a brick, and he's banging on the window with a brick. They've broke 2 of the locks, and then eventually they've pulled out their police baton, smashed the window, come in. At this point, I ran to the front door, sat down. The gate was locked, so I'm trapped now between the front door and the gate. And then the police officers come, open the door, grabbed me, picked me up, squashed me against the gate, forced me on my belly, tied up my legs, took the keys out of my pocket, put me in the van, kept me overnight for about 23 hours, took me to the Magistrates court the next day for breaching the peace, which was his initial arrest, was breaching the peace while I'm behind my front gate and just refusing not to let them in. Obstruction, resisting arrest, and assaulting the police. And yeah, the next day in the Magistrates, he said, do you want to deal with it here or in the Crown Court? So I said to Crown Court, obviously. And when I got there, they had dropped all the charges except for obstruction. So it goes back down to a magistrate. And then after a couple months, they tried to get an adjournment because the police officer was sick. So they wanted to vacate the hearing.
They said he was sick.
They said he was sick, yeah. I was also sick. I went to court. I said, so I made myself available. I cited some case law, and the judge sided with me and said, we should proceed today. And then the prosecution come back and offered no evidence. So
wow. It's amazing.
Since then, I've done some digging through Freedom of Information requests to the court. I discovered that the warrant was issued within 10 minutes under a bulk issuing rubber stamping situation. I also pressed the head of legal services for a copy of it, and she admitted in an email that she just printed it off to get me a copy, because every warrant copy I asked for at the bottom would have a produced on date, so they can produce it at will. So that formed part of my argument that any one of them can just...
I'm very tempted, but I don't want to interrupt you. I'm tempted on every level. So many things.
You're doing well. You're doing well, Anthony.
I'm holding myself back.
It's been going on. It's almost 2 years now. In April, it would have been 2 years since it happened. So since then, I could have just took the police to court for smashing my window and this and that. I did make a formal complaint to the police, who after 6 months said they've done nothing wrong. And then I pushed it further to the IOPC, and they agreed some points need readdressing. I highlighted that some of my property went missing during the invasion. And then they've come back another 6 months later and said, actually, while you was in the van, 2 more officers attended. They went into your bedroom. They found some watches, checked the serial numbers, took them to the car, and then they don't know what happened to them.
Wow.
While I was arrested in the van, obviously the police came in. They searched the whole house. They searched the loft. They've obviously searched my bedroom, carried out an illegal search. And then they left the enforcement company unattended in my house. And yeah, so I've got like 20 legal grounds I've put to them. Cost me over £10,000 to get it into the Royal Courts of Justice in the King's Bench Division.
Right.
I'm suing them. At first I said I wanted 525,000, and then after I discovered some more, I pushed it up to 800,000. I just thought, why not? You know, I might as well take them for as much as I can. I don't think I'll be lucky to get 8,000. I'll be lucky to get 800 quid, to be honest. But
we got like time issues, Elf. I'm very I'm thrilled to hear your case and the way you're fighting back. It's amazing. But if you're happy, I'm happy to discuss with you at more length, or maybe even record a separate video going into more
Okay.
depth. But what we're doing here, we have a campaign called Stop Court Order Scams. Yeah?
Yeah.
So you've spent £10,000 for all your costs going into court and stuff. I'm going to give you something for free. Are you on the chat?
Yes.
So there's a link I put there. Check my court file, criminal, and I put a link to a document there.
Yeah. Clicked it.
So you put your case number into that document, yeah?
Yep.
And that's the only one single item you need. You don't need nothing more.
Okay.
Yeah?
Yep.
Now, so that will destroy your case, because the initial warrant is everything in your case.
Yeah, that's once that falls, everything else
Everything.
crumbles.
So you don't have to fight the rest of it and waste £10,000.
Yeah, because for me, it's like I was arguing that they shouldn't have come based on that warrant. The police weren't entitled to act under that warrant, and the warrant.
No. Let me switch the language up. Yeah.
Yeah.
That there was no warrant. They had
There was
a
no warrant.
counterfeit. Right. They had a counterfeit item. Yeah.
Yeah.
And this link I sent you, you can email it today. It's all you have to do is put your case number there, nothing more. You read it, put the case number, it's one page.
Yep.
And it's enough to destroy everything.
That's
because
what
the problem is they can't produce what we're asking in the way that we ask to verify the initial warrant.
Yeah.
All the other stuff, I'm saying it for you and the benefit of others. All the other stuff that you describe is horrific and stuff. It's drama and it's compensation. As far as I'm aware, don't discuss none of it. Only discuss this initial warrant. Only.
Okay.
Your burden will be light, like a matchstick. You understand?
Yes.
If you break the back of it,
Yeah.
then the other stuff is for a redress of grievances. You can load up the kitchen sink now.
Okay.
But in order to win and break all you're doing, you're trying to burst a balloon.
Yeah, I've kind of made a trail. I've kind of said it started from here. These people involved.
Yeah.
These people. And then
Right.
I've taken them all to court. I've tried to take. I've got individual
No.
officers.
No,
And
you
five
need to just
defendants.
destroy the initial one, and then they're all in a conspiracy.
Yeah.
So what I
Yeah.
recommend you do, you get the postage sticker from the post office. I recommend second class to save money. The signed for, yeah,
Yeah.
that one. Where is it? I'm trying to get it in front of the camera.
Yeah. I've got them.
And you peel off the thin strip and
Okay.
stick it on the document itself. So the document proves itself. Yeah? It
Yeah.
saves a lot of administration and it scares the daylights out of them. Then they go, oh, somebody knows how to do this. Yeah? And all you're doing, you're asking, not just for you're asking, right? Let me show you something. You're not just asking for the warrant. You're asking for the warrant that was executed.
Mm.
Yeah? Because they have to endorse it and file it back in court. You understand?
Yeah. When I first initially filed my claim, it was like I was just 200 pages. Boom. I sent it all to them. I've said every case law and everything, and then they come back saying it should be struck out. It's too long. So then I amended it. So I have a hearing to amend my claim, to add additional individual officers, and it's also a strikeout hearing. So
I will give you 12 words. Yeah? 12 words of magic. And that is all the 12 words you need. I have never been served with any proceedings issued by the court. Full stop. Because it's not just a warrant. They have to make an application for the warrant, right?
I put in a freedom of information request, and they've got no notes.
You don't need a freedom of information. That's a scam. Don't do freedom of information. You write to the court and you ask them, You write to the police, you ask them the same question, Mr. Chief Constable, and forget the officers who came to your house. Forget them. They're little boys. Go for the Chief Constable who bears the vicarious liability.
Yeah.
Mr. Chief Constable or Mrs. Chief Constable, there was an incident. Don't go into details. There was an incident involving a warrant being executed. Provide me a copy of the warrant that was executed on which your officers acted. Game is over, my friend.
I've asked them for a copy of the body cams. They won't provide.
No, forget all that. That's drama and compensation. Only the warrant. Just isolate this point. Be like a scientist. Isolate things. This is the only thing that matters. You understand? All the other stuff, you bring it out. What if you win the case and you want compensation? You bring body cam, you bring everything. Yeah? All the neighbors as well. You bring them, they were disturbed. But for now, small acts. Yeah?
Yeah. I have tried to, that was what my main attack. I've got a file, the warrant attack file. It's my main thing was disproving the legitimacy of the warrant.
You don't have nothing to prove. You ask them to produce the warrant. You don't have no burden of proof. They came to your castle.
That's right, yeah, and they showed it on a digital screen.
I'm not interested. That's not a warrant. Okay?
Yeah, I want a paper copy.
I can copy and paste 1,000 on my tablet or my screen. That's not a warrant. And not only just a warrant, the warrant that was executed. That's the one that buggers them up, yeah?
Yeah.
So you got the police chief constable, you got the court manager. Do some homework and find the court manager, write to them, addressee only.
Yeah, I was in correspondence with them, and then when I served them my claim, I didn't hear nothing back. And then after a few months had passed, I asked her for an update, and she said she sent it to the legal department, and they I tried to say that they didn't acknowledge service, so I put in a judgment for failing to acknowledge service, and then they said it needs to go to the Treasury solicitor. That's how you serve the MOJ, and I was serving the HMCTS. So they're trying to play on
listen, my friend,
that department.
We have a process here. You request from the court manager, addressee only, the items we put in the document, the link we sent you, right? Because you want to see the court file, you want the computer record of the case, and you want the warrant, the sealed warrant issued by the court. You see the 4 magic words, issued by the court. Yeah? This is what kills them, because they're giving you something, but it wasn't issued by the court. So by putting in these words, it just destroys their bullshit, because issued by the court kills frivolous paperwork.
Yeah, they sent me directions from a judge presiding, the district judge. They've sent me.
Well, you heard us talk to Paul McGowan about them misusing the authority of the judge.
Yeah.
Forget all that. You're gonna get buried. They're all on big, huge, fat salaries and bribes. Yeah. You're gonna waste energy. Just stick to give me the warrant that was executed.
Yeah. So how does it? So if they've sent me a copy of the warrant that they claim was given to the enforcement company, then what further can I ask?
Because this is the problem, right? You ask for a warrant, they give you a something and say it's a warrant, which means they're insulting your intelligence that you don't know what is a valid warrant. That's number one. But secondly, someone can make up a warrant and put a stamp on it. We got more than one bailiff. They said they got a court stamp in their car. Yeah?
That's right.
We had a bailiff attend my flat in Enfield a few months ago, and he gave the tenants a notice of eviction, and he took a stamp out of his pocket and stamped it.
Ridiculous.
Yeah? So it doesn't mean you're not verifying the warrant. Yeah? You're verifying the proceedings. You understand?
Yeah, because that's what I kept trying to press them on that, because on the top of their thing it said it was issued in 10 minutes. Something. How can you issue a warrant in 10
But
minutes?
where is the application?
Yeah, they didn't have the application. They didn't have
So you don't have an
permission.
application. There's nothing in the computer.
Yeah.
So look, we got a time pressure. So, you know, thank you for bringing your case. To put that, if you want, you get in touch with me. I will tell you my ideas, how I operate. Because what you need is minimalist effort and time and energy. And once you break the back that the warrant is fake, the house of cards collapses.
That was my main thing, was doing that.
That's the right concept, right? But we've been practicing it 12 years, so we have a little experience. And you will see them packing up and running and hiding and resigning and all sorts, because you ask for it in the right way.
Yeah. All right. Well, I see the time is limited, but it's been good to connect with you guys now. So
yeah, no worries. You stay in touch with us, and lots of people are fighting and building their cases. And eventually, we don't get justice. We're going to take the Lord Chancellor, but your case must be very built at the foundation.
Yeah, I've amended my original claim. It was 200 pages. I've condensed it down now to like 10 pages or something, and and been more specific about it. So next month,
talk to us about it if you wish. We'll show you a very, very minimalistic way. Anything you do in these matters that goes more than half a page, it worries me that you're doing something wrong.
Okay,
All right.
Well, next month I'm due to go present it's a strikeout hearing, and to see if my amendment can survive. So I've got that.
Well, the bottom line is, up to now, I have never been served with any proceedings issued by the court. Mr. Chief Constable failed to provide me the warrant that was executed. Mr. Court Manager can't produce any computer record, and that's the matter. That's all you have to say. It's over. And if you don't sort me out, Mr. Your Honor, I have no option but to escalate the matter to the Lord Chancellor as a conspiracy.
I put that in there as well, actually.
Right.
Yeah.
All right. Anybody else have anything to ask, or that's itching them, or is everybody happy and contented?
Do you have Anthony's? Are you connecting? Do you want to connect up and chat against this offline? I don't know if you want to chat.
I'm sure he'll find us, Andy. Not
a
problem.
Will.
If the police can find me, he can find me.
Anybody? Is there anybody else that has anything else to say? Or are we good till Wednesday? Yeah, well, I think we're good till Wednesday.
Okay.
Yeah, on that note, Alf, just like I say, you'll know a way of contacting us one way or the other. But like I say, my motto is this: keep it simple.
Who is this?
Can you Wednesday? What time, please?
6 o'clock.
Okay, thanks.
UK 6 p.m. tea time. UK.
Okay, thank you. Yep, great, thanks.
All right. On that note, I'll love you and leave you all. Have yourself a lovely ending to the weekend.
Okay, thank you.
And
Thanks.
I'll see you in the week. God bless all.
Thank you very much. Bye.
Take care now. Bye-bye.